Good evening, everyone. Welcome to this evening's presentation, The Breakdown on Heirs Property, hosted by Alachua Conservation Trust. My name is Heather O'Bara, and I am the Associate Director for ACT. I am joined this evening by Emma Olmos, who is the Conservation Events Coordinator for ACT, and she just turned her camera on to say hello. In addition to Emma and myself, we are delighted to be joined by Candace Spencer, who is our guest speaker this evening. Before we turn it over to Candace to start her presentation, I'd like to just go over a few logistical items for this evening's talk, and then we'll get started. First and foremost, this event is hosted by ACT, and for those of you who are new to Alachua Conservation Trust and may not know much about our organization, we are a nonprofit land trust accredited with the Land Trust Alliance, and our mission is to protect the natural, historic, scenic, and recreational resources in and around North Central Florida. And we protect land through acquisition, donation, and conservation easements in 16 counties in the North Central Florida area. Tonight's presentation is also part of our Keep Florida Wild virtual series. If you'd like to support future conservation education programming, in addition to tonight's talk, please consider making a donation by texting Florida Wild to 44321. We greatly appreciate your support for important programming like the one that we are about to hear tonight. In addition, if you know someone who was unable to make it to tonight's talk, or perhaps you'd like to watch the talk again in the future, we are recording live to YouTube right now, and I see some folks are watching us on YouTube, so welcome to all of you. The presentation will be available immediately on Alachua Conservation Trust YouTube channel, so just search our name and you should be able to find that presentation. And you can share it with folks who might like to learn a little bit more about this evening's topic. We will also be conducting a question and answer session following Candace's presentation this evening. So please feel free to submit your questions at any time. You can utilize the chat or the Q&A function that's located at the bottom of your screen. We are unable to recognize folks that have raised their hands, and we can't turn on cameras for anyone who's participating as an attendee. However, if you send your questions to us through those two mechanisms, we are more than happy to save them for the Q&A. And if you're watching us on YouTube, you can also submit your questions to the chat, and we will work those into the Q&A lineup as well. So I'd like to introduce our guest speaker this evening and turn it over to her. Candace A. Spencer is a Florida barred attorney who works in the field of environmental mediation and facilitation with a focus on food and agriculture in Washington, D.C. She was introduced to the topic of heirs property while conducting a legal needs assessment of Black farmers in North Central Florida during her third year at the University of Florida Law School. So after graduation, Candace conducted academic research on the implications of legal remedies to heirs property contradicting cultural perspectives of land ownership. In her professional position at the University of Florida Conservation Clinic, she created the Environmental Justice and Community Economic Development Program area and supervised student associate projects, which included a comparative analysis of relevant Florida probate law and the Uniform Partition of Heirs Property Act, technical support for the creation of the Heirs Property Program offered by the Communities That Care Community Land Trust located in Gainesville, Florida, and an analysis of the political feasibility of enacting the Uniform Partition of Heirs Property Act in Florida. Candace is passionate about equitable land ownership and increasing Black land ownership of agricultural land, which fuels her interest in remedying heirs property issues. While she lives in DC, her heart stays in Florida, and she is the vice president of the board of directors for Working Food, a Gainesville-based organization dedicated to building a resilient local food system. And I am looking forward to your presentation this evening, Candace. I'm going to turn it over to you. And if anyone has questions, do please feel free to enter those into the chat during our presentation. Candace?
Awesome. Thank you so much, Heather. And then Emma, if you're able to do the slideshow, Emma's doing the technical part for me so I can focus on what I'm actually saying. Awesome, thank you so much. So as a brief bit of background to recap what Heather shared about me, I'm a licensed Florida attorney, a Florida barred attorney. Emma, would you mind changing the slide for me, please? Thank you. I'm a very proud double Gator. I have a bachelor's degree in environmental science from UF, as well as a law degree and a certificate in environmental and land use law. As Heather mentioned, I am also the VP for the board of directors for Working Food. I sincerely love that nonprofit and working and the work that we do and working with them. This is a brief bit about that. We have a community kitchen, a robust local seed program that does seed saving, is connected to seed saving in the Southeast, and also a youth gardens program that's connected to community organizations like the Greater Duval Neighborhood Association and the Environmental Ambassadors Program as well. I am also really passionate about racial equity in agriculture. It's something that I've dedicated a lot of my professional career to, and I'm super excited to be talking about Heirs property today. And so let's dive on in. The big question is, what is heirs property? Heirs property is legally unrecognized shared ownership of land simply because title to land hasn't been transferred from someone who owned it and died to the people that are now living and own it. So it's also known as clouded title. And so when you clear up heirs property, you now have clear title. It's based on a tenancy in common land ownership structure. And I know it sounds kind of legally, but it basically means that everyone has a share in the entirety of the land. It's not that one person has 1 acre, another person has another acre. Everyone has an interest in the entirety of the land. Everyone also benefits equally from their land ownership. The drawback is that no one is automatically responsible for things like paying taxes or handling any legal issues with the land. And no one has to work together either. If they want to sell their interest or give it away, they can do that without talking to their other co-tenants, and the co-tenants don't have a say in what another co-tenant does with their interest in the land. So the question is, how can it happen? So usually a landowner dies without a will, or a will that doesn't meet state requirements. This is important to know because someone can execute a will and think they're fine, but if the state requires 3 signatures and you only have 2, it's not valid. Or if they require signatures from someone who doesn't benefit from your will, and everyone who has signed like the witness forms actually benefits from your will also isn't valid. So it's important to not just have a will, but one that is valid within your state. And if the case is that a landowner doesn't have those things, then the property ownership passes unofficially to the heirs. It's unofficial, it's not legally recognized because the deed or title is still in the name of the deceased landowner. So for example, because I love examples, at the time of his death, we have Ferdinand, who had 5 acres of land, 6 children, no spouse, and no will. That means that his 6 children are now all co-owners of the 5 acres. It's important to note, it's not that they each have 0.83 acres. I'm also very proud of this math, y'all, because I went to law school, so I don't do math. But it's not they all have 0.83 acres, it's that each child has 1/6 interest in the 5 acres. However, they can't do anything with that or benefit from that because the property is still in his name. So they can't provide proof of ownership until the title is cleared. So what's the problem with heirs property? I think it's probably pretty obvious by now, but there are some really significant issues with owning heirs property. Without legal recognition of ownership, heirs property owners are locked out of the benefits tied to land ownership. So one thing that's common is disaster FEMA assistance. Everyone is living in Florida or from Florida. We all know about hurricane season. And I believe it's actually storming in Gainesville right now, unfortunately. But one really common example with heirs property and disaster assistance is Hurricane Katrina in New Orleans. After Hurricane Katrina, when a lot of homeowners went to apply for disaster assistance from FEMA, they were unable to because they had clouded title. A lot of people also didn't even know until the disaster happened, and so that left them unable to access that assistance. It's also difficult, if not impossible, to get a mortgage or financing for improvements on your land with heirs property because banks and financial institutions won't accept a partial land interest as collateral. So if you wanted to get that financing, you'd have to have something else to put down as your collateral. As I mentioned, my area of expertise and my passion is about agriculture, and so that's how I always approach heirs property issues. And for heirs property owners who are farmers, until very recently, there was no way to access USDA programs, U.S. Department of Agriculture programs, such as farm loans or other financial assistance, because the USDA requires farmers to have a farm number. In order to get a farm number, you had to be able to prove land ownership for the land that you were farming. That did change in 2018, and I'll actually talk about that in a little bit. And the last is just a general area of income generation if that's what someone wants to do with their property. If the heirs property owner has forest on their land, they can't sell that timber without proof of ownership. If they wanted to run another business venture that is tied to the land, they simply aren't able to do that. The biggest problem, though, with heirs property is its vulnerability to loss. Everyone knows what a valuable tool land ownership is and what that can do for wealth generation, for family legacy. Heirs property is really vulnerable to loss. One way is through a tax sale. As I mentioned earlier, tenancy in common means that everyone benefits, but no one's technically responsible until you decide or designate someone as the one who's in charge of handling taxes and other legal issues. If no one's paying taxes, property taxes, the city can repossess the land and then resell it in a tax sale. And that happens actually quite frequently. One of the biggest problems, though, is, like I know I've said that, but partition sales are actually the biggest problem, so much so that they have their own slide. So in a partition sale, an heirs property owner goes to the court and says that they want the monetary value of their share of land. Having the land is not what they want anymore. They want whatever value is attached to their interest. So the court says, okay, orders the land to be sold, and the proceeds, minus any fees, are divided up among the co-owners according to their ownership interest. So going back to our example, let's say Damien, one of Ferdinand's heirs, petitions the court for a partition sale. If the land is sold for $36,000, each of the 6 heirs receives $6,000 because they each have a 1/6 interest in the land. Again, I'm very proud of this math, y'all. This is in contrast to partition in kind, where someone would say, I want the actual land. I want my 0.83 acres of this land. I don't want to sell it. I just want the actual physical land. That is much preferred to a partition sale because it divides the land up so that each co-tenant can do whatever they want to do with it. Some people don't want to sell, some people do, some people want to build a house, some people want to have a farm. They're able to do that because they now each have their own parcel of land. This is actually preferred, technically is the preferred legal method, but there's been a lot of court doctrine has emerged in favor of partition sale instead, because it's simply easier to sell it and divide up the money than it is to actually go in and divide up physical land. But there are definitely problems with partition sales. Number one is that because it's a forced sale, the court's ordering a forced sale, which means it usually happens via an auction or a sealed bid process, not on the open market. The land is severely undervalued. So it's an additional slap in the face to co-tenants who maybe don't want to sell. If it does sell, you're not even getting the full value of the land, and you have to pay court fees, and so you're also getting less than the land is worth. Additionally, as I mentioned, some people may not want to sell. Someone wants their monetary value, someone else may not. And so because of tenancy in common ownership, the person asking for a partition sale doesn't have to give a heads up, doesn't have to give permission, can just go to the court on their own and say, this is what I want. If an outside party buys that land and there are owners living on it, they can then be evicted and have to leave. The biggest issue, though, with partition sales, hands down, is predatory development. A developer who wants to buy a particular piece of land will seek out a co-owner, a co-tenant, willing to sell their interest. After buying that interest, they are now co-owners in this property, even though they're not an original heir. They can ask for the partition sale, and they always have the money to buy the entirety of the land, which they then develop for profit. This tactic has facilitated a lot of coastal development, like Hilton Head, South Carolina, and displaced a lot of original owners of land, a lot of whom happen to be Black, which leads me to our next question. Who tends to own heirs property? So heirs property is an issue in diverse areas of the country, from New Mexico to Maine, but it is predominant in Black communities and low-income communities. And heirs property is known to be a significant contributing factor to the decline of Black land ownership in this country from the early 1900s to present day. In 1920, Black Americans owned 15 million acres of land, mainly in the South and mainly farmland. And there were 925,000 Black-owned farms, which amounted to 14% of all farms in the US. In 1975, there were only 45,000 Black-owned farms. And today, Black Americans are less than 2% of US farmers and 1% of rural landowners. Access to and fairness within the legal system is a dominant reason for this decline. Heirs property can be avoided by executing a will that follows state requirements for wills. However, Black Americans historically have not had adequate access to the legal system and to legal representation. Additionally, the legal system has been used to oppress and rob Black Americans of their rights and of their land. For example, it wasn't unheard of for there to be separate courthouses for Black legal documents and white legal documents simply because of segregation, and for the courthouses that house Black legal documents to mysteriously burn down so that all those documents, all that proof was gone, which then allowed the facilitation of theft and robbery of land because Black people were unable to prove that they did in fact own that land, so those documents were now completely destroyed. So even if Black Americans were able to adequately access the legal system, the system could and was and still is used against them to dispossess them of their land. And this history of discrimination and theft and oppression understandably made many Black Americans distrust the legal system. So even if there was access to, there may have been an unwillingness to actually engage in the system that tended to be used against people. For people in families of lower income, it is a matter of financial access. It is expensive to hire an attorney. It almost always has been. And so the ability to access legal representation and to understand the legal requirements of a will were simply not available. In writing an academic paper a few years ago, I explored some preliminary research on the cultural views of land ownership and how they contradict property laws in the US. The very idea that someone can own land is fairly Eurocentric and unaligned with indigenous views of land ownership and other ways of viewing land occupation and use around the globe. Collective land ownership and responsibility, where the entire community benefits and the entire community is responsible for the well-being of a place, are important and valuable viewpoints that aren't allowed space under US property laws. For example, there's the Gullah Geechee Nation. They're recognized by the UN as a sovereign nation, and they are people directly descended from African people brought to the US and forced into chattel slavery, particularly on the eastern coast of the US on the Sea Islands, which stretch from Jacksonville, North Carolina to Jacksonville, Florida. Due to the relative isolation of the Sea Islands, descendants of enslaved people in that area were able to maintain a culture and foodways and language that are separate and distinct from the evolution of Black Americans on the mainland of the US, including collective ownership and communal well-being. The Gullah Geechee Nation has also suffered dispossession of their land due to issues with theirs property and predatory development. And so after talking a bit about what it is, who it affects and why it's a problem, a natural next step is how do you fix heirs property, right? And you have to clear title. I mentioned earlier, having heirs property amounts to clouded title, so you want to clear that title up. And that simply means that title to the property is transferred from the deceased landowner to the living heirs. I know people always have questions about how exactly do I go about that? It's going to be unique for everyone because the simplicity or complexity is directly related to how many people are heirs of the land. If you have 3 people, much easier than if it's been decades and you have hundreds of people trying to resolve heirs property. Sorry, next slide, please, Emma. So I'm going to come back to that a little bit, but I do want to talk about heirs property and public policy because my background is obviously policy and law. And there are some public policy things that are designed to help out heirs property owners that play a role, especially in the state of Florida and especially for farmers. So one important piece is the Uniform Partition of Heirs Property Act. It is a state level model act that states can adopt and personalize that provides protections in a partition sale situation. I mentioned earlier, partition sale, the problems with it, predatory development, and how it's a tool for that. And the UPHPA is specifically designed to protect in those situations. The notable provisions are first notice. As I mentioned, when you're seeking a partition sale, you don't have to tell anybody else that you're doing it. But with the UPHPA, you do. You have to post a sign on the property, a conspicuous sign, not like a little tiny post-it, that says, the petition action has begun. This is where it's happening. This is the information to find out information about it. Also, an appraisal If the co-tenants don't all agree on a price, the court has to order an appraisal done by a disinterested real estate appraiser for the fair market value of the property. I mentioned again earlier how sales are normally done, the way sales are normally done with a partition sale, you don't get the fair market value. Under the UPHPA, a fair appraisal must be done. There's also the right of first refusal for co-tenants. As I mentioned again, people can come in and buy the whole property up because they have the funding to do so. Under the UPHPA, with the right of first refusal, another co-tenant can buy out the person who wants to sell, not the whole property, just that particular person. So if Damien's trying to sell, his brothers and sisters can say, we will buy you out, you can go on about your way, here's your money, and we get to keep this property still. Another provision is an open market sale, unless the court finds that a sealed bid sale or an auction is more financially beneficial. But usually an open market sale is much more beneficial because you have more people coming in to see the property, there's competition, and that can get you the fair value of the land. And also it's required to think of partition in kind considerations. As I mentioned earlier, partition in kind isn't really favored by the courts. It's a lot harder to divide up physical land than it is to divide up finances and money. But the courts are required to consider things like sentimentality, use of property, how long the property has been in that person's family, like what the land means to them. Those kind of things aren't normally considered in the law are able to be considered here. At this point in time, 17 states and the Virgin Islands have enacted the UPHPA, and the states are diverse as Mississippi and Texas and Connecticut, and thankfully also Florida. Florida enacted the UPHPA into law in 2020 of last summer. And this came after a concerted effort by a number of people and organizations like Kent Wimmer, Defenders of Wildlife, J.Y. Seabrooks, Jamie Coleman, who I had the honor of being on a panel with last year, Sandra Thompson at FAMU, working with the Florida Bar, the legislature, and grassroots groups as well. I became involved in heirs property issues in Florida in 2017, as Heather mentioned in my intro. And the UPHPA seemed like a really long shot back then, so it was amazing to see it passed into law last year. Next slide, please, Emma. Another important piece of policy for the UPHPA is a 2018 Farm Bill. So the Farm Bill is a piece of federal legislation that has to be passed every 5 years, and it covers everything ag, like conservation and commodity crops and crop insurance and all of these things, research for agriculture, a ton of different things, and most things food related, including Supplemental Nutrition Assistance Program, also known as SNAP. The 2018 Farm Bill authorized several provisions to assist farmers who are heirs property owners, but specifically, purposely made it easier for farmers who are in states that have the UPHPA, which encouraged a lot of states, 2019 and 2020, to adopt the UPHPA so they could say they were supporting the farmers in their state. And those provisions are a lending program to help clear title. The money goes to organizations that have a history of working with heirs property owners, so no one can just pop up and say they're helping and then misuse the money. And also alternative documentation to prove land ownership. As I mentioned in the beginning, without a farm number, you can't access those USDA programs. Without documentation of farm ownership, you can't get a farm number. So being able to provide something else that says you've been on the land for a while, whether it's paying taxes, whether it's other proof, like other ways to prove ownership or prove that is in fact your land, even without a clear title and a clear deed, has been important for farmers who are also heirs property owners. And so finally, coming back to how to fix heirs property, how to get help with it. I wanted to list a few resources here if you own, whether you're heirs property, someone you know is an heirs property owner here or another place in the South. It's predominantly an issue in the South, although I mentioned it ranges all over the country. So a lot of the resources are focused here in the South. So there's a Georgia Heirs Property Law Center. A UF Law alum actually works there who's amazing, so I can definitely recommend them. The Center for Heirs Property Conservation is based in South Carolina. The Federation of Southern Cooperatives works throughout the Black Belt region. And then locally operating with offices in Gainesville, Jacksonville, and Lake City is Three Rivers Legal Service. Can also vouch for their work. I know some of the attorneys there and do recommend them. And then with that, I'm happy to answer questions. I didn't want to take up too much time because this is not a lecture. So happy to answer your questions.
Thank you so much, Candace. That was a really wonderful overview of heirs property. And we do have some questions that came in, and I'm actually going to turn it over to Emma to ask you the first question.
Okay.
Hi, Candace. That was so great. So one of our first questions is about partition sales specifically. And so for the partition sales, it's kind of a clarifying question. If one of the heirs decides that they want to sell, even if all the other heirs don't want to sell, they can still put that parcel up for a partition sale?
Yes.
That's kind of crazy to me.
It's actually like really pretty whack, but that is it's also like let me clarify also, it's also a property right. Like tenancy in common means everyone can benefit, everyone can do what they want to do with their share. So even if it's unfair to other people, it is still a property right to be able to say, I want to be out, I want to sell, this is what I want to do.
Right.
And I also want to do a quick clarification. The UPHPA does not hinder that right. You're still able to do a partition sale. It just protects the other co-tenants in that situation.
Right. We also just got another one, which is, are there areas in Florida that are more impacted than by heirs right properties than others? And can you speak to that a little bit?
That's a great question. So the last time I looked at the data for heirs property, it was a little bit of a while ago. There's not comprehensive data on exactly how much an area has heirs property. I know Joan Fox at UF Law and a couple of her students were doing research on this a few years ago. I want to say like 2 years ago. So I don't remember the numbers, but my personal guess is that if you're talking about rural, farmland ownership, North Florida would have more than like say South Florida. South Carolina claims to be the state with the highest percentage of heirs property. So there's also that, but I don't know exact numbers right now.
All right, I'll take the next couple that came in, Emma, and then I'll turn it back over to you. Is there any remedy for properties that have already had a portion already sold?
I guess my question would be remedies as in, it's a lawyer me being like, it depends. And what do you mean by that? I do have a question like remedies as in what, as far as like getting land back or as far as?
So yeah, this one says if it's like already sold to a developer. So I didn't finish the question, I should have. But that, yeah, if that doesn't clarify it, if the person who asked wants to follow up with that one, maybe we can ask it again.
Yeah, I think a follow-up would be helpful because if the question is how to get it back, I can't speak to that. So some clarification would be helpful there, just so I understand the question.
Okay, excellent. So the person who submitted that, if you want to follow up with a follow-up question, we'll definitely make sure we get to that. And for those folks who are submitting questions, please continue to do so in the chat and the Q&A. I'm seeing them come in, and we will try to get it to as many as possible this evening. And we're scheduled to go to 7:30. We probably won't go that long, but we will try to get to everyone's questions this evening. So I'll take the next one, and then Emma, I'm going to turn it over to you to take a few more. So this next one is, are heirs limited to the landowner's children, or their grandchildren, great-grandchildren, etc. as well?
So that depends, which is, again, a classic lawyer answer, but it actually does depend because each state has a way of saying how things pass when someone dies if they haven't said how that's going to happen. So if you want to, so typically it's like your kids, if you don't have, it's like your spouse, your kids, your parents, and then it keeps on going like that. But it's going to be up to each state as to how they determine who the heirs of someone are. That depends who is living in that person's life and what their relationship is to that person when they die. So the answer actually really is, it does depend.
Okay, great. And Emma, I'm going to get to that question we had asked again. She sent a clarifier for us. So I'm sorry, Emma, I promise you can have a couple more when I'm done.
Oh, it's fine. I was gonna get to that one too, so.
Excellent. Okay. So is there any, so this is the follow-up to that first one that we said we asked for a clarifier. Is there any legal way to help that person regain that portion of the value of the property if it's already sold to a developer? So if it's partitioned and sold, is there any way for them to get the value back?
I don't think so, but I'm gonna say officially that is a question you need to ask an attorney. And I want to clarify, obviously I'm an attorney, but I can't answer like very specific questions, but that gets into attorney-client relationships and things that are kind of messy. So I can't answer very specific questions. I want to be clear about that. So my answer is I don't think so, but I would absolutely double check with an attorney who can advise you specifically.
Yes, thank you so much, Candace. That is, unfortunately, sometimes that's the answer we're going to have to give this evening, just because we have some questions that are very specific, and also they could be legal in nature. And so we want to make sure that you get advice from a professional attorney in a setting where there's confidentiality that applies. And since this is a public webinar, we can't necessarily do that. So, yeah, I'm going to turn it over to Emma to ask the next question.
All right. So if a person leaves a legal will and it's passed on to, like in the example, the 6 children, would that be considered an heir's property that could also go up to a partition sale, or is that now just a different type of thing altogether?
So if they left a will and they wanted to go to their 6 kids, like if, in my example, Ferdinand, if he said in my will that's legally executed, that's follow state requirements, it goes to my 6 kids, that's not heirs property. They then have clear title, but it's still tenancy in common. The problem with heirs property is that it's this joint ownership and it's not legally recognized. So even if it's legally recognized, you still have joint ownership. So you could actually still do a partition sale.
Okay. All right. Now I'm going to comb through some of these questions that are coming in. So if there is an heir, so say it's divided up to these 6 people, but one of the 6 children, the heirs, is consistently paying property taxes. Is there any way that the Florida courts will give them preference in determining ownership or anything? Like, what happens if one of the heirs is kind of interacting with the land, but nobody else is?
Unfortunately, that doesn't necessarily come into play. Under the UPHPA, I think that is something that, as far as like partition sale versus partition in kind, I think that's a consideration to come into play. But as far as weighing their opinion more, that doesn't really come into play, unfortunately, because someone has to pay taxes. Like, they should be paid anyway, and so even if it's like one person that over everyone else, they don't really consider that.
Right. All right, I'm going to pass it back to Heather to ask a couple more questions.
Thank you, Emma, and thank you to everybody who is submitting questions. They're all wonderful that are coming in. And we are going to try to get to as many as possible. For those folks who are watching on YouTube, which we have quite a few, if you have any questions, please feel free to submit it through the chat option, and we will also incorporate that into the Q&A. I've got it on my second screen next to me, so I can see those coming in. So I'm going to jump around a little bit on some of the questions we've got. Here's one that just came in. Would a partition sale still be allowed if the property is put into a family trust?
Oh, that's a great question. I'm not actually sure. I haven't done trust in estates in a long time. I'm not sure. That's a great question. I'm going to be honest with you. I don't know. That's a really good question.
Okay, so maybe we can. Candace's contact information is on the screen. So if you wanted to follow up, maybe she could find that answer out at a later time.
Yeah, I'm going to write that down.
Thank you for that great question.
Yeah. Okay.
Let's see. I'm looking for a couple more questions. We've got some great ones coming into the chat. Some of them are specific, so I'll do my best, but this is a good one. How far down the genealogy does the term heir go if one of the original 6 heirs dies and has 3 children? So how do you qualify as an heir? How far can it go?
It'll keep going. It will absolutely keep going. Like, it doesn't, so if someone passes away, then their heirs now have their ownership interest, and it keeps fractionating. I can't do that math, I told you I went to law school, but it will keep fractionating. So you can have someone with like a 117th interest in a piece of property because they are the great granddaughter of someone. It will keep going forever until you remedy it and essentially stop that.
Emma, would you like to take the next couple ones?
Yes, I'm kind of combing through all of them all right now too. I don't know, because I can't go back to see if it was on the slide, but someone asked if, I don't know if you have any association with them, or the Three Rivers Legal, is that a good resource to refer heirs property descendants to? Do you have any?
Yes, it is.
Okay, so yes.
I spoke with those attorneys personally, and they are good people. I recommend them.
So, and then also, let's see, I'm getting some more in. Oh, how can you identify heirs property? Is there a way to do that?
You would go to, what is the office called? The local, is it property appraiser? Property, I'm completely blanking on the name. I'm so sorry. There's, wherever you pay property taxes, because I don't own a home and
the property appraisal, yeah.
Okay,
yep.
yes,
yeah.
You can go there and ask for the records and look for the records, and they should be able to tell you like whose name is on the deeds. That's something that's actually public information, and so you should be able to get that information there.
All right, so the questions are coming in. This one is, are there loan programs that will allow one heir to buy out the other's owner's shares?
I don't know the answer to that question, actually. It would depend on what kind of loan you were looking for, because there's different kinds. So I'm actually not sure the answer to that question. It would depend on the kind of loan you're looking for, though.
I'm gonna slide it back to you, Heather, to see if you've got any on YouTube Live or anything there.
I don't, but we've got some great questions coming in. I don't know if we're gonna get to all of them. Somebody did say Farm Bill as an option for programs for heirs to look to potentially to buy out other shares, and I'm not sure the answer to that. Although for the person who asked that, please feel free to follow up with Candace or with ACT, because we are working on Farm Bill programs right now at Alachua Conservation Trust, and we might be able to get that answer for you as well. Let's see. I'm gonna hop on over to the chat because I feel like we've got a lot coming in there, and we are going to we're going to get some of those. And I'm not sure about this one, but I'm going to ask the question anyway. Does the law limit the minimal fractional interest that can trigger a partition sale?
No, it doesn't.
Right.
Which is another reason why partition sales are a property right, but also problematic.
Okay. I want to see if we answered this. Okay, what if a partition sale is involved with a land swap? For instance, you're trading a piece of property for a different parcel of property. Would an appraisal be needed? And what if the parties agree to swap, since only one heir is needed for a partition sale request? So that was a lot of questions in there.
It was. Can you run that back one more time?
Yeah, we'll do them piece by piece. Let's do that.
Okay.
So if the partition sale is involved with a land swap, would you need an appraisal for that?
I'm not sure. I will be honest, I'm not sure.
Okay. And then the second part of that question was what if the parties agree to swap? So since only one heir is needed for a partition sale request. I'm not quite sure what that question is kind of getting at, but Candace, you might be.
I'm not fully sure, but it sounds like they're asking if you would need the permission of everybody for the land swap, since you don't need the permission of everybody for the partition sale.
Yeah, that makes sense.
But if you are swapping the entirety of land, you would absolutely need everyone who's also an owner, who's also a co-tenant in that land, because they still have their interest. They still have their interest. And you're not going to a court, you're going to another party. So you would need everyone's permission for that.
All right. Emma, do you want to take a few more?
Yep. I have one right here, which is when you are clearing the title, does it usually go to a single owner? Or do you continue having the land be fractured and now just under separate titles?
It's going to depend, like really and truly, that depends on what the family wants and what they are able to agree to, which is why heirs property can get so complex. You have to have agreement among the heirs on what y'all are going to do with this land. And that's just going to depend on the people involved.
Awesome. And then when talking about making wills, what do you think are some of the biggest obstacles for people maybe not having wills that pass, either not having wills in general or not having wills that pass the state regulations? What are some of those biggest obstacles that create heirs properties?
There's a few different things. One of them is this general aversion to thinking about one's own mortality. Like, no one really wants to be thinking about that, which is required when you make a will. Like, that's not something that's typically very joyful, at least in this country, maybe in other cultures. So it's the idea of like having to really think about someone's mortality. A lot of people, or some people, don't like the idea of having to like what feels like picking favorites of who's going to get what. And that's just like a preference thing. Like it's also not necessarily that, it's just a matter of like making sure who gets what is like up to you, like your standards and like who you know is gonna take care of it, like kind of like your preferences. But some people feel a version of like they're gonna feel like their feelings will be hurt, or they're gonna feel like they picked favorites, or things like that can be a barrier. Part of it is when it comes to following the requirements, a lot of it's just lack of knowledge. People will think that if I write it down, I sign it, then it's fine. And that may not be the case depending on your state. Like every state has their own requirements, so you have to be really clear about what those are and follow those. And then it's usually best to have an attorney help you. And so if people don't have access to an attorney, there aren't a lot of attorneys around, or there aren't a lot of affordable attorneys around within their price range, or they haven't found one that they are able to work well with. That can also be a barrier. Right.
And then this one kind of came in, and I think it's a clarifying question in terms of what the interest is in concept. It's not actually the interest that each heir has is not this like a specific drawn out portion of the parcel of land. It is the interest in the land in general. So until the title is cleared, or until there is maybe a property sale or not, so it's property sale and property value. Are those the two different?
Partition sale and
partition sales and partition value. So until there's a partition sale, that land is conceptually owned by all, and then once the sale happens, then they could be drawn out into like you get this part of the actual physical property.
So in a partition sale, you're not getting the actual property. The land is being sold to whoever buys it, and you get your monetary value of it. Mm-hmm. Partition in kind, you do get your actual like physical dirt, like that is right. Those are your boundary lines. Yeah. Right.
Okay. So until you could do an in-kind sale or get the title cleared, all of this is not about connecting your interest to a specific part of the land, but more of the concept of like the land as a total.
Yes.
Okay. Heather?
Yes. Here's a question that's come in. And I know we can't delve too deeply into heirs property. We talked about that solutions, but I'll ask the question. We can say we're not, we might not be able to answer it, but can you discuss complications with heirs properties and lot line encroachments and any potential solutions?
Lot line encroachments? I'm going to say no, I cannot. And maybe ask a clarifying question of exactly what they mean by lot line encroachments. I'm thinking, I have something in my head, but I want to be clear about what they may be asking.
Okay, sure. So for the person who asked that question, here we go. I've got the clarifier. When a house is over the lot line.
So like your neighbor's house is over your lot line? Okay, and can you go to the original question again for me, please?
Oh no, I dismissed it.
Oh.
I'll get it back. Okay. The original question was, can you discuss complications with heirs properties and lot line encroachments and any potential solutions?
I can't speak to solutions. Actually, yeah, no, that's going to be one that's a little bit, because I have a lot more follow-up questions that I can't actually get into that would help me understand like how you would fix that. So that is a little too specific. I'm sorry.
Okay, sorry about that.
Yeah, sorry, it is a good question though. So I'm like, oh, I wonder how that works, but I cannot.
Gotcha. Okay, thank you. This is a great question that came in. Is there any work being done to locate heirs property descendants whose ancestors may have lost land during the Great Migration?
Oh, so not to my knowledge, but so that's a good question, because now I'm like, I want to do that work. but it is hard to, so going back to the question about how much Heirs property there is, the Federal Reserve of Atlanta did some research, I want to say in 2017, they had some like preliminary numbers of the amount of Heirs property in the South. And I don't think they've built upon that at all, or continue to update that. I haven't checked on that, but I don't think so. That sounds like a really fascinating research project, but also a really in-depth one, because you're looking at literally the entirety of the South and then having to trace that back. And so, not to my knowledge, but that would be a really cool project.
I can follow up and say Defenders of Wildlife wrote in and said that they're actually working with the University of Florida to develop a model project, learning how to identify potential heirs properties.
Nice.
Yeah, so it looks like there is an organization working on that with other legal aid groups and land trusts to help identify heirs properties in the area. So so Defenders of Wildlife. Yeah,
that sounds awesome.
Those were both timely questions that came in. So thank you so much. Emma, I'll turn it over to you.
Yes, let me see. Okay, so in terms of the way that heir property passed down through different generations, if an heir in, let's say, like the first generation down, so the children of whoever who passed away and didn't have a will, do they have like, I don't know how to say this other than like priority heirness over then, like if one of those heirs from the first generation passes away and that goes to their heirs, is there any like differentiation between like the children versus grandchildren versus great grandchildren and priority over that heir's interest?
I don't think so. It's triggering some other property things for me, but I don't think so. Not from what I know about heirs property. No, their interest is smaller because of just how math works. But I don't think they have priority as far as like what would have like going to them versus the grandchildren.
Okay. I'm looking at the questions. There's a lot of really cool comments, but I'm reading through. Let me go to the chat, see if there's anything here. And if there's anything on YouTube Live, Heather, let me know.
Not yet. But I'm watching. Well, Emma's looking for a new question. And there's some that are coming in. Somebody made a comment, and I do want to mention it to folks who are listening, but Three Rivers Legal Services, who we were just talking about, they have attorneys on staff who can help with wills to help protect future generations and also to clear title to heirs property. So that's an excellent resource that Candace provided earlier, and somebody who's familiar with them also mentioned that they have those services available to folks.
A question just came in, which was kind of like, what are the first steps to take if you think that you would like to do, if you feel like you are a part of an heirs property and you want to get title cleared or something like that?
I would check to first check to see if you actually do have heirs property, and I would do that with the office's name I cannot remember for the life of me. The property appraisal. Property appraiser's office. And then contact an attorney. Like, there are some things, I know people are like, do I need an attorney? There's some things you can do by yourself. This is not one of them. You're gonna need an attorney to help you with heirs property issues. So my next step after determining if you have heirs property is to contact an attorney.
Yeah, that was okay. All right, so there's a question that might be a little more maybe philosophical in nature, but when talking about culture and land and how our legal system does not account for a lot of non-Eurocentric culture and land understandings, how could we incorporate those into the legal system and that we kind of are working in that framework already in?
That's a great question. I love to philosophize about stuff like this. So that's a really good question. So from what I know and some research I'm doing, just like from learning different things. So this is an interesting question, because the answer is going to sound a little bit different than I was telling Heather earlier. So depending on how people want to handle their land, like land trusts are a way to handle them, but not necessarily land trust owned by like, it would have to be like land trust owned by like a community. So like that's one way. People who are coming together to say, I've seen a lot of that when it comes to like Black farmers who are coming together to say we want to collectively farm and collectively live. So that's one way of doing that, where the land is owned collectively. And you can also, heirs property sounds really bad because it is a problem, but you can actually have joint ownership of land in a way that isn't problematic in the way that heirs property is. So that's also an option. You could actually jointly own land in a way that fits into this legal structure that we have. You could set up a land trust operated by a community of people. You could set up an organization that owns your land for you, for the community to do whatever you all want to do. There's some really cool examples of that in, I want to say Boston, of a neighborhood having their own community land trust, and like they own all the homes in their neighborhood, and the people who residents there on the board can decide like how that land is handled, if it's like who's living there, like how things are going to be done to avoid gentrification, to avoid like blight. Like they are really handling the things for their community in their neighborhood. If you're operating within the system, there are some things like land trusts that can be helpful, not necessarily for remedying heirs property, but for like collective land ownership and really kind of subjugating a little bit the property laws of the US. If you want to talk about outside of capitalism, that's a whole other conversation. But within the current structure of property laws here, I think that's land trusts, something that I know of that are a fairly good option that can provide some like self-determination with property when it like this still is collective, that still operates within the US system, that's not going to cause you problems like heirs property does. I love that question, so thanks for that question.
All right, Heather.
We've got a few more. We're not going to get to everything tonight. We're getting close to 7 o'clock, and I think that's a good time to round out our Q&A this evening. But if you have very specific questions and you want to reach out to Candace, whose contact information is on the screen, I'm sure she'd be happy to answer questions if she can. But you can also reach out to ACT, alachuaconservationtrust.org, and we can help maybe direct you to the right resource to help you get more information about your question. So this one's going back to lot line encroachments. This question, it says, I can see issues if a neighbor sues about a lot line or easement and heirs property is not settled. Who takes responsibility for that land if there's a pending lawsuit against it?
That's a good question. Okay, it's everybody's responsibility, actually. That's one of those, the problem with heirs property I mentioned is that everyone benefits, but no one's technically responsible, but that means everybody's responsible. So all of the co-tenants will be responsible. The problem is that it's not going to say their name, it's going to say the name of the original landowner. So the person suing is going to have to deal with that. It's going to be a mess for them. It's a short answer of that. But it would be everyone would be responsible for that. It's just a matter of like getting even to that point, because it's going to look like you're suing somebody who no longer is living, because that's who's on the deed. So it's going to be a problem. That is a good question.
Yeah, everybody's sent some really excellent questions this evening, so thank you so much.
Yeah, so I just want to do a lot of like legal research I haven't done in a while. Like, ooh, let's think about that.
And so I think we've gotten to most of the questions, unless they were like very specific or and we weren't sure we could answer them. But if you have follow-up questions, please feel free to reach out. This presentation will be available on our YouTube channel immediately following when we wrap up this evening. So if you'd like to check back with us and see this presentation again, I know there was a lot of information. I just want to say thank you so much, Candace, for joining us from DC this evening. The power of Zoom it's very exciting to be able to connect with folks that are in different areas of our country. So thank you so much for being here with us this evening, giving this wonderful presentation on heirs property.
Thank you all so much for having me. This has been a lot of fun, and I really appreciate the good questions as well.